So I am, unfortunately, a failed computer designer turned lawyer, which makes for quite an interesting career. I am also extremely cynical. And so with some good humour, I thought I would chat with you for the next half an hour or so about the law and technology and whether it works or not, and whether actually there's a better method of law and technology in this kind of cybersecurity and IT field. So that's the plan. And where's the magic button? And so I'm going to talk about 4 areas. I'm going to have a look at some examples in the past about whether laws worked. And here I'm going to chat about hacking and a bit about electronic signatures. And then I'm going to just tell you a long laundry list of new laws that are upcoming that interest me, and probably not you at all. And then, the exciting bit, we're going to have a chat about some new fun stuff, or indeed any other fun stuff you can challenge me with. You can say, what about X or Y? And I will tell you how well or badly the laws, present and future laws, might work with that technology. And then finally, once you're fed up with that, we can see if this whole law thing's a nonsense. And maybe we should do something else instead. And if that is true, maybe you guys in this room might be able to figure out what that is. How does that sound? So let me start then. On hacking. So if you're as old as I am, and as do I always proclaim I've never been involved in personally hacking anybody. But of course I know it wasn't against the law prior to 1990. So that saved me in that statement. And Robert Schifrin and Steve Gold, of course, were the most celebrated examples of discovering whether there was existing law worked for hacking when they hacked Prestel. And again, you have to be of a certain age before you remember putting your telephone into the 300 baud, or actually it was 1275 baud modem. The acoustic coupler went in, and then a page like teletext would come up. I'm sorry, some of you don't know what teletext is, never mind. And then you type in numbers, and more pages would appear, and that was just tremendous. And Robert and Steve accidentally found that the administrator's password was on one of the login screens, and they logged in and had some merriment, as you might expect. And so at that time, and I remember it reasonably well, amongst the legal community, there was a whole bunch of various random theories about how you would have existing law to cope with that activity. And we thought about trespass and public nuisance and theft of electricity and all these kind of crazy ideas. And the one chosen by the prosecutors was the Forgery and Counterfeiting Act, and that didn't work either. And the judge pronounced, and I've had to look it up because I didn't know what it meant, the Procrustean attempt to force the facts and language of the Act not designed to fit them. So basically, they had to hammer out some solution into this Act, and it didn't work. So there's no existing law for hacking then, and so we have a law that we know well, the Computer Misuse Act. And it is extremely trigger sensitive. You can't move without being in breach of the Computer Misuse Act. It is a wonderful sledgehammer to crack a nut. Even arguably, if you are not getting the web page that you want and decide you want to manipulate the URL to a different web page, you've breached the test here. And woe betide you if you forget your passwords for your secure encrypted vaults. Anyway, so we've got this extremely broad law. They must have captured every form of hacking in that law, but no, they forgot about denial of service attacks. So here we are, 2006 now. After the sledgehammer, now come the jackboots, and there's now a specific offence to cover denial of service. Not much help to Mr. Lennon here. Wasn't very impressed with this, because he actually got prosecuted under the prior version of the Act for essentially a denial of service attack. Unlucky him. But in the process, with the jackboots, it seemed like a good idea to have some more laws. And now we've got laws that are much closer to this one, which is that if you use tools, it's a bit like tools, are you equipped with tools for a robbery? Is that crowbar in your pocket, or are you just pleased to see me? And if it's because of the intention of a robbery, then that is an offence. And so there's an analogue here. And of course, as you know very well, there's that very tricky dividing line on why you're using that version of Linux, either as a security tool or for hacking. It is the same tool used for both. And much ramification and happiness, And even then, the Home Office decided in 2014 that actually the law there wasn't quite strong enough. It wanted to clarify the law in relation to coming equipped with these tools, and we now have the current version, as of a few years ago, which says that if there is now intent to use the tool, then it's only that should be the offence. And before you celebrate to say that is all solved, I will remind you that in order to commit crimes, actually you just need the intent. So say you're merely port scanning, and someone spots that, they say, ha-ha, there's intent for hacking there, we've got you. How funny is that? So, there we go. 3 goes at it, Sledgehammer, Jackboots, and the Knuckle Dusters, and they've still not quite got this right. So I'm going to pronounce this one as a fail in terms of technology matching the law. Let's look at a different one. Electronic signatures. Now, the lawyers have been somewhat busy with this because they think it's quite important. Over 20 years we've had this. Because, understandably, being able to execute contracts and sign things is quite important for commerce, and if you're doing commerce by email or over the internet, kind of a good idea to figure if this works. And so, this lot, I'm going to pick on this European Directive from 1999. And unfortunately for me, as you'll discover, I was apparently one of the country-leading experts in this directive in about 1999 or 2000. And in this directive, they had this grand idea that if you formed a particular type of signature, then that would be absolutely functionally equivalent to the real signature. Pretty straightforward. But to do that, it came with a huge amount of baggage. We had PK certification authorities had to be on registers, we had audit requirements, we had everything, this superstructure to build this requirement for official, legally binding electronic signatures. In 1999, that's quite forward thinking. And then what happened? Nothing. No one used it. My expertise was almost entirely wasted. No one touched the thing. Business merely carried on ignoring this law in its absolute entirety. Don't worry, it's back from the dead. So back in 2010, the European Commission thought that it would be a good idea to bring this thing back. It's really important for cross-border services in Europe. You've got to have electronic signatures. So back it comes. And it's come back in a new form called EIDAS. Don't know why it's called EIDAS, that's what it's called. And it's basically the old one, the e-signature directive on steroids. So we've got the signatures and things, and we've now got trust providers, we can authenticate documents, authenticate websites. I mean, if it moves, we can authenticate it. It's brilliant. It has a few loopholes, perhaps. It doesn't actually harmonise emission to signatures today. There's local variation to still, manage an opt-out. And so, but on balance, it's brilliant. Now, let me just remind you, in case you don't know, what the law is for electronic signatures under English law. And it's been like this for some time. There's plenty of case law that says if you send your signature on a fax, that's a valid electronic signature. That was even a case, you remember ages ago, when faxes were sent, there was a little, often pink circle would be printed on the fax on the sending piece. If you had a case about that being valid as signature and acceptance. Online buttons, the I buy at Amazon. Perfectly happy for that to be a signature. The law is accepting of that. And in fact, who is that nice chef? Name will come to me in a second. That's a ghostwriter machine on the left. And the chef's father-in-law was accused. Thank you very much. Sorry, it's my old timer's disease catching up with me. Merrily used the card that you slide into it to recreate your signature. So if you have a Ramsey cookbook, signed on the inside cover, may not have been by his hand exactly, could have been this machine, but they used it for deeds and properties and guarantees and so forth. And that clearly was good enough for a signature, even for a deed, a guarantee, a slightly higher standard for signatures. And then even if you go to a web page and type in your name into the box, the bottom of your Ashley, signature. Say I'm not very good at typing, maybe even my initials, APW, signature, X, signature. Absolutely no requirement under English law for this 20 or so years of turmoil and fancy European rules, because the existing law here has worked perfectly adequately. So let's look about the future. Shield your eyes from the next page. This is what I do. I spend a lot of time these days looking at the General Data Protection Regulation. And I might just, because I can't help it, just show you a quick slide about that in a second. That e-privacy directive, and that was a contender for my talk actually, that was that directive that gave you those terrible banners on websites. Click here if you know what a cookie is or have heard of cookies, or click here if you want to ruin your user experience with our website. Whatever that message is, that comes from this e-privacy law. The Network Information Security Directive, just passed now. PSD2, extremely exciting new law, particularly in the financial services space. This law that's, amongst other things, will allow you to give consent to social media companies like Google or Facebook or other to access your bank accounts through that platform. Access all your bank accounts through that platform. Obviously, the banks love that law because they have the cost of running a retail bank and no actual kind of customer interface. Never mind. So that's causing a lot of excitement. Trade secrets has now been harmonised across Europe. And even aside from those statutes, we have a tremendous amount of new developments affecting technology in this space. We've got an Austrian guy called Max Schrems, a student, who has managed to invalidate some really important bits of privacy law. If I meet him, which I'm due to in the summer, I will buy him a pint. He's made me lots of money. Thank you, Max. And perhaps not his intention. And he's not finished. It looks like even more international privacy law might be upset by the cases he's bringing in the courts. And then we've got Brexit. Again, Christmas come early for lawyers, you might think. And that might well be right. So lots of new developments. Actually, as a little sort of nerdy sideline. Remember in that previous slide we were talking about the electronic signatures? Just a bit of law with you for a second. I won't do this often. But on this prior thing with this slide will do. You see, it's called a regulation, and the prior law was called a directive. And it's worth just keeping that in mind, because a directive, a European directive, is an instruction to the countries in Europe, the member states, to write their own laws that are supposed to be consistent with that directive. So we have for the Data Protection Act, for example, and of course it's nothing like the laws in other countries, but that's just another quirk of how things work in the UK. But here, if it's a regulation, it is actually this language that becomes effective in the country. So why am I telling you this? Because on Brexit, it's exactly those laws, the directives, that we'll get rid of. Because those are the ones that come directly, have a direct effect from Europe. Anyway, sorry about that. I'll try not to talk about law in the future. Oh, yes. So let me talk about the GDPR just for a second. I said I would. And the reason I want to talk about this in terms of future developments is because it will have a wide-ranging effect on you. And it is delightful, because in any briefing papers you might see or send to your boss or similar, you can point out in the first couple of bullet points that the maximum fines are now up to 4% of worldwide turnover. That is helpful if you like making sure that board members have sleepless nights. And so it will affect whole tranches of your technology, and in fact, secretly, I think that technology might be the solution to this, rather than the things that people are doing with lawyers and consultants at the moment. But that talk is for another day. So, I said that having given you an idea of what the panoply of new laws that we've got, I said I would look at some new things, stuff, interesting things, and we'll see how well these current and future laws will fit with these technologies. And I'm happy to talk about any others, but these are just the ones I thought of a few moments ago. Now, in this section, I'll give you my bias here is that I think that good law should be technology neutral. And I think that because intuitively I just can't see lawmakers or the courts keeping up with technological change. And so logically, the answer to that is write the laws in a technology neutral fashion and they'll apply to any variant of technology going forward. That seems like a very straightforward premise. Let's see if they've managed that. Strong authentication then. Now, you will all know what strong authentication or two-factor authentication is. However, in the financial services world, the European Banking Authority, the European Commission, the European Parliament also think they know what it is, and it's actually something slightly different to the one that you think it is. And I won't drag you through the exact definition, but it's up there on the page. And in the most recent guidance, just a month or so old, which I would commend you to if, just on the last link on this page here, which I'd commend you to, in the most recent guidance, it says these sorts of things. If it's got to be technology neutral, it seems to me odd that we have all these extremely specific requirements. No attempts more than 5 times. You must check to see if the devices are rooted. You've got to have blank out characters before users see them when they type in their passwords. Really specific behavioral stuff. Where it should just be saying, you must keep it secure. So I actually think it's probably not working in terms of this, is it technology neutral? We have now very specific requirements. And so if your job is involved in this, which is authentication for any form of payments, the law comes into effect 2018, then you absolutely be all over these requirements. Look, another one in the financial service space is breach notification. Now, as we all know, there's just chronic non-reporting of breaches. I mean, it's just true by everybody. And that's partly because in the UK, under present law, reporting breaches, unless you're a telco, is essentially voluntary. Not so under the GDPR. And in the GDPR, you're giving a very nice 72 hours to figure out, get your initial reports together and figure out how to notify the authorities. This is on top of your requirements if you're a financial institution and you have to report to the FCA or report under the NES or similar. So that sounds kind of tough, but not completely unworkable. However, under this new plan, they want to sharpen you up a bit. You're not given 72 hours, you're given 2. 2 hours for your report to the authorities. I would commend strong coffee near your desk at all times. I've picked out the worst of the examples for slight dramatic effect, which you might imagine. This is obviously very serious breaches and so on and so forth. But even so, I kind of think 2 hours is quite tough. And that's the standard that will be held to if these guidelines there come into effect in early 2018. So fail there. I think too specific and may not be workable. Let me try a third topic with you. Artificial intelligence. Now, actually, the story's a bit different here. In quite a lot of ways, the law is further ahead than you might think. We've had for many years provisions in the copyright IP legislation in the UK, provisions dealing with automatic generation of works, because computers have generated, music and poems and other nonsense themselves. So there's a question of authorship of that, and that's fixed. We've got a solution for that. In the question of AI for self-driving cars, that sounds like a brilliant idea. presumably I can just shove my kids into the Tesla and they go to school on their own, is what I'm hoping for. And, in that, we've got a bill going through Parliament, just making sure that the insurance for those cars is worked out. I think it's rather forward-sighted of the government, with the exception, of course, it'll make insurance for everyone else much more expensive, but let's not dwell upon the negatives right now. For financial products, if you think about that online company Nutmeg or similar, they're supposed to look at your parameters and it's kind of robo-advice to deliver advice. The FCA is happy to look at that. And there's a body there for analysing how that might affect in terms of your financial regulation. So there's more there than you might think. Perhaps the bit that's not going so well is my job, is the commercial contracts. We have no idea at all how to draft contracts for AI. We're quite used to drafting contracts that say, you build thing to this specification, and if you go through these acceptance tests, if it doesn't fail, that sort of model, and because the person giving you the neural net's not the person giving you the test case to train the net, and because we can't even tell whether it's working or not, we have just no idea. We're flapping around on the beach in relation to that. So just when we thought everything was rosy with artificial intelligence, let me just pick out a provision of my favourite act of the day, the General Data Protection Regulation, and it's this. In the weeds of this, it is now a requirement for you to tell users the logic involved of any automated processing that has affected individuals. That could be a bit tricky. You can show them the chip, but I'm not sure quite how you're going to be able to explain how the logic works. But through your various filters and feedback mechanisms, it's just not possible. So we'll figure out a way around that, hopefully. Let me pick on another topic. I've got a little flag here. Let me talk about Bitcoin and blockchain, and I was sorry to miss the prior talk, actually. I should have come earlier. So this is really interesting, actually. There was kind of a flurry of excitement in the legal world on Bitcoin, and a whole bunch of papers produced. And if you were to read any of them, actually, I would read the one in the middle, the EBA paper. That is still the best banking regulators' view of Bitcoins, and that's absolutely the best one. And that was all in kind of 2014, 2015. There's a bit of a lull. And then it's caught people's interest again in the law side, and not in a good way. So my understanding of Bitcoin, that apart from being very good for money laundering and drug running and so on and so forth, you don't know who the person is. And that's part of the attraction. It's a bit like paying in cash. I think there has to be a society need for paying in cash, paying anonymously, and Bitcoin in part achieves that. Or it did. Slipped into something called the fifth anti-money laundering directive. Is this. Now remember, in the anti-money laundering world, this is the laws that banks and foreign exchange providers and anyone who takes your money has to go through, and even solicitors when I take on clients, you have to go through and check who the person is, or if it's a company, check who the company is, check who owns the company. And then if you're receiving money from the company or other services, you've got to keep an eye on it in case anything suspicious. Like the client appears with a suitcase full of cash, for example, slightly suspicious. And you have to report them. And there's a tussle in the legal world about client confidentiality, tipping them off for offences, but anyway, we've got to report them. So under the fifth anti-money laundering directive, they've snuck in Bitcoin exchanges and wallet providers. So when this European law comes into effect, which it will do shortly, all Bitcoin transactions need to be registered, monitored. You need to tip people off if you think it's suspicious. They're going to be busy. So in a stroke, I rather fear that this might have somewhat affected the happy Bitcoin world. My view is if you have Bitcoins, now's a good time to sell. Even then, again, I just can't, it's not so important, but even the GDPR there's a whole bunch of interesting and crazy rights given to data subjects, including the right to be forgotten. That is the very thing you can't do on the blockchain. You cannot forget. It is always an open register. And so we'll see how that measures with technology. So not such a happy effect there for Bitcoin. Before I talk about the future of law, any other topics we should quickly discuss? Please.
Investigatory Powers Act.
Oh dear, I didn't include that because it's quite tricky. But I mean, essentially, the short answer is, as you know, we have the most tremendous degree of surveillance in the UK, subject to the government, of a type that would have been, well, and was in fact rejected by prior governments. And you will know, and I'm going to offend someone in this audience at least, but the telcos, of course, seem to be remarkably quiet in relation to this because they're paid, as you may know, for the black boxes that monitor your communications. And it's quite a good profit centre, I understand. And things are all going in that direction. And I would say that with Brexit, we'll be increasingly going in that direction because we'll no longer have the European human rights. There might have been any countervailing balance against that monitoring. So, is it limiting technology? No, I think technology is working quite well for it, but it's a good question because it's certainly affecting our rights. Please, at the back.
Just on that point about the EU, there's a principle of equivalence. I know it's not called equivalence. I've forgotten the right word for it, but effectively our laws got to be seen to be equivalent to theirs, to have due exchange with them. Now, surely that's going to have an impact on all of these laws, and we don't have complete freedom to do what we want after Brexit.
Yeah, so I think what's going to happen, the best we can tell, and who knows now, but the best we can tell is that we will have the Great Repeal Bill. And if you'd asked me this a few weeks ago, a month or so ago, I would have said it was going to be exact copy and paste between the European law straight into English law. And the reason for that is not enough Parliament time to adjust all the laws into a way that we might want. So then we have a copy of the European law. At that moment, post-Brexit, we then have the equivalence, exactly the same law, although open to a question of which courts we go to. And then over time, pretty certain that the UK will water down its version of the laws and try and hang on to the equivalence. That's the model. We may find, I now hear, that some laws might be watered down initially, certainly in the data space, and that seems to be happening now. And then that equivalence will be more difficult to get. With 5 minutes to go, let me just rattle through this last bit. Well, what's the future of law? Can we fix all this nonsense, this mismatch between laws and technology? Well, there's some good examples already. We have got the European Commission have the online dispute resolution portal. You log in there. There's loads of providers who will fix your disputes online. I don't know whether it covers who gets the cat or the CDs on a breakup. I'm not sure, but everything else needs to be covered. And there's some great stats about who uses it the most. And I was very pleased to see, I've blown this up, look, Brits, we just love complaining online compared to everyone else. No one else really cares, frankly, apart from us. So I'm pleased the European Union is getting good use of that. What we'll do post-Brexit, because you won't have this clearly, I don't know. But at the moment, Brits love complaining with that. So if you've got an idle moment, maybe you can spark a couple of complaints using this portal. Some handy researchers have done an interesting thing. They fed lots of judgments, for human court judgments, into an AI net, and it still worked afterwards, and they were able to predict the outcome of cases. So that's judges gone, for starters. So we could just send the submissions into the chip, and it'll, like a pendulum, or actually a thumb, yay or nay, and you can see whether you're guilty or not. So that could save some time, and elderly judges can go back to the retirement home. So that's a good development. Smart contracts, that's supposed to be heralded as to the future. I'm afraid this is a slide from PwC. I have no idea what it means, but I think what it means is that there's contracts that are smarter than the ones I draft, probably, and they might be drafted by you. In fact, we had to go at drafting up to smart contracts for another talk, and we thought that a good application for a distributed ledger would be corporate bonds. To explain what they are, doesn't matter. But anyway, we drafted it up, and it kind of looks a bit like computer code. So rather than having overpriced lawyers, because I sit at the desk with a quill, as you would expect. Instead, you're going to have your local programmers knock up your contract in a bit of code. So that might be the solution to contracts. That sounds quite sensible. People are putting AI into a whole bunch of other things. We've got some trying to make lawyers smarter. That's an easy win there for Ross Intelligence. Lot of AI in e-discovery. That you get kind of millions of records and things. You have to figure out the smoking gun where you lose the case and all that kind of stuff. Generally, it's the emails the senior execs are deleting. Actually, is the way you look. But anyway, the AI helps you find that. Some guys I know well at XNR are using AI to help with GDPR compliance. They're quite good fun. We've got AI to review contracts. So I just give it, it tells me what the answer is. This sounds great. I'm still going to be charging my usual rate, though, just to let you know. But that's law gigs in the States. And lastly, Deloitte, rather than happily saying that myself and 113,999 colleagues are going to be made redundant because of AI. And so with that, I fear I need to get my coat. Thank you.